Welcome to today's webinar, Privacy and Cybersecurity in the New Normal. My name is Alex Cameron, and I'm joined here with Antoine Aylwin, and together we're co-leaders of the Fasken Privacy and Cybersecurity Practice Group nationally. We'll be moderating this webinar and look forward to an engaging discussion with our panel of experts from our team across the country, who we'll introduce as we go through, but briefly, Daniel Fabiano, who's a partner in Toronto, Kateri-Anne Grenier, who's a partner in our Quebec City office, Lorene Novakowski, a partner in Vancouver, and Darren Reed, a partner in Calgary, and special addition, Jennifer Stoddart, who is a strategic advisor in our team, and the former Privacy Commissioner of Canada, who will be well known to many. The real impetus for the session today was to sort of take stock of where we're currently situated in terms of grappling with the evolving set of privacy issues that we've experienced in the pandemic. Obviously, there's been a rapid evolution of questions and issues faced by business in terms of workplace, employee issues, sharing information with government in the name of public safety, a range of new and interesting cybersecurity risks and threats that really have changed the landscape in terms of where Canada is currently situated, and certainly has been keeping a lot of our team very busy across the country in giving guidance to clients on these. And we wanted to share some of the learnings that we've gleaned from some of those experiences in terms of what's arising. So that'll be the focus of today, is to really kind of work through some different themes that are common and crucial in terms of where we stand today and where we're likely heading in the coming weeks and months as we come out of the pandemic. And so with that, I'll turn it over to Antoine, who will provide a short overview of how we're going to unfold the program today.
Thank you, Alex. Hello, everyone. Please note, today this program is being recorded and will be made available in the Fasken Institute for other registrants or other participants that did miss the live session. The survey at the end will be sent to you, so you just click on the link underneath the video so that you could fill out our survey. It's very important for us because it helps us cover the topics you want to hear from us for the next sessions. And in fact, as Alex mentioned, in the latest weeks, the situation has changed a lot. By mid-May this year, we were planning to talk to you about the new PIPEDA that was supposed to be published by spring to meet GDPR requirements. We're waiting for the same thing in Quebec. The agenda seems to have been revised since then. But I think we have a great opportunity to discuss with you topics that are relevant to the reopening of the business now. Today we'll be discussing 4 topics with our speakers. First one will be privacy in the workplace. Second one, the risk management issue. We'll talk about hot issue right now, contact tracing, and we'll talk about also everything that's related to customer relationship in this new situation and the reopening of the business. We'll be doing duos, so Alex and I will be hosting each of us, one speaker, one after the other. We'll have a Q&A session at the end. So we already received questions from you when you registered, but during the program, other questions may be raised. You have a chat box below, so feel free to send us as many questions as you like during the session. We'll try to answer them if possible on the fly or at the end of the session. Following the webinar, if you follow our Twitter feed, which is at FaskenLaw, we will recap the key questions raised in a Twitter Q&A. So this being said, Alex, I'll let you introduce our first speaker.
Thanks, Antoine. Lorene, if we could have you come on to camera. There we go. Hi, Lorene. And you take yourself off mute as well. First up, Lorene Novakowski will be speaking on the employment-related issues, as Antoine mentioned. And Lorene will be known to many as a leading labor, employment, and privacy lawyer based in our Vancouver office and heading up our privacy team in Vancouver with a focus on advice to businesses, employers, and extensive experience with privacy litigation and at all levels of court. So certainly no stranger to the field. And with that, I guess, Lorene, I'd just ask generally if you could maybe kick us off with some comment about what's new in British Columbia.
Sure, thanks, Alex. I'm happy to. So the BC Privacy Commissioner has issued a number of bulletins that are available on their website. They have joint guidelines on COVID-19 contact tracing with the other commissioners. They provided extensions for public bodies. So there's 2 different extensions. It gives public bodies another 30 days to respond to access requests that were received in April and May. And they also have a very helpful tip on privacy compliance while working from home. Issues such as password protecting mobile devices, making sure that others in the household can't see any documents containing personal information, secure storage, etc., all of which is very useful. And then in March of 2020, they issued a ministerial order which amended FIPA, which has a general prohibition on disclosure of personal information outside of Canada. So they amended it to allow very specific terms, healthcare bodies and public bodies to disclose personal information outside of Canada for COVID-19 related purposes. So that's sort of generally what's been happening in British Columbia.
Wow, yeah, lots of activity, and I know a lot of interest on that, the cross-border one in particular, the lessening of that, and maybe we may get to that a little later in terms of whether that might stick around, but we'll see only for COVID work now. And then on the employment side, maybe some comments on where we're at in the employment side.
Sure. So I'm going to kind of focus on BC and Alberta PIPAs and BC FIPA. I think most people know that dealing with employee personal information, the test is you have to give notice and the purposes have to be reasonable. And if you're thinking about reasonableness in British Columbia, the leading case in BC is the Cone decision, which sets out a proportionality test considering things like how likely it's going to be effective to collect the personal information, and are there other less privacy alternatives, privacy intrusive alternatives. Alberta's test is more of just it's a subjective test. It's an objective test, not a subjective test. But you also have to take into account that there are exceptions in both of the PIPAs for disclosure, consent, disclosure without consent, collection, use, and disclosure without consent, where it's required or authorized by law, or where there's legislation or a statute that allows you to do so. So in this context, we want to be thinking about public health orders, which I think are have the effect of legislation, or at least subsidiary legislation, and also WorkSafe BC in British Columbia and workers' compensation legislation, occupational health and safety orders that also authorize or require employers to collect, use, and disclose personal information without consent in certain circumstances. So we need to be having that lens on this particular situation as well. Public sector employers, we know that their legislation is authorization-based, not consent-based, but the collection still must be necessary, and there's a test as to what's considered necessary. And also, though, taking into account that the FIPA legislation also has exceptions for disclosures, consent without consent, so collection, use, and disclosure without consent, where there's a legislation that allows for it. So taking into account public health orders and what they allow for, particularly in different industry, and also WorkSafe BC in different industry, might be helpful to employers to decide what they can collect and what they cannot.
Yeah, so maybe to take from there and drill down into some of the specific issues that I know are coming up from the general framework that you've provided there. can employers ask for employees if they have COVID symptoms? I know it's a question we've been getting a lot of, among others. Would you mind addressing that one?
Yeah, and I think it does invoke privacy concerns, but there might be other sort of more passive ways to deal with that. So, for example, in British Columbia now, with our return to work guidance that we got from WorkSafe BC last week, all employers, regardless of industry, are required to post signage that tells employees that they must not enter if they have symptoms. There's also a toolkit that was developed that employees can use. So you go to the online toolkit and it asks you if you have any symptoms, and if you do, it can direct you to a collection center where you can get tested now if you have symptoms in BC. So the WorkSafe BC guidance also requires policies to be in place, training, so all of that can be used to advise employees, don't come to work if you have symptoms, and here's what to do if you do have symptoms. If the employer still decides that they want to collect that personal information, if the employee has told them that they do have symptoms, you should have a policy in place. You should make sure that you're only using that information for that particular purpose. You should be thinking about having very crisp retention schedules, not keeping it too long, and keeping it securely.
Right. And from there, in addition to asking about symptoms, is there a basis for employers to ask employees to provide a medical note from their doctor related to COVID?
Well, if an employee is asking for sick leave, an employer generally can be entitled to a sick note, subject to, for example, maybe a collective agreement restrictions. But other ways to deal with that are, again, ask employees to use the self-assessment tool, ask them to go get tested if they have symptoms, but also think about how useful a note's going to be. So if it's someone who's had COVID-19 positive test, who've been off sick, do you want a note for them to return to work, clearance from a doctor that allows them to return to work safely? That might be reasonable in the circumstances and not offside PIPA or FIPA.
Mm-hmm. Right. Okay. And you sort of mentioned it in passing there. Another of the questions: can you ask employees to get tested before you allow them to return to work?
Yeah, and we were getting a lot of these questions before the contact testing became more widely available, at least in British Columbia. But if you have reasonable grounds to suspect that an employee does have symptoms, you hear them coughing, they haven't reported to you that they have symptoms, they're at work, I think you've got reasonable grounds to be able to say to that employee, we need you to leave the workplace, decide if you're going to pay or not pay, and ask them to get tested. And again, the question comes up, well, are we as employers entitled to the results of the test? And so, we had actually one situation where a public health officer was saying to our client, you're not entitled to the result of the test, but really didn't explain why. But from a privacy perspective, if the employee's tested negative, you're going to want to know that so that you can allow them to return to work. But again, if you're collecting highly sensitive personal information, you need to have policies in place. You need to treat it carefully, retention schedules, secure storage of that kind of information.
Right. Yeah. Related to that, I know another was been the subject of a lot of discussion among the business community and among the public health officials recently in terms of its efficacy. But can employers take employees' temperatures for the purpose of determining if they have a fever before allowing them to attend the workplace? Comments on that additional potential activity that might be looked at?
Yeah, I certainly think there's a risk there of a breach of the privacy rights and dignity of employees. I know the BC CDC, they have the list of symptoms, and it does include fever and chills along with cough and sore throat. So at least in British Columbia, that's one of the symptoms that our CDC has said exists. It's not required under any of the WorkSafe BC return to work protocols, and it's not required by provincial health either. So, you'd be looking, if you're going to implement it, is it reasonable in the circumstances? And for some industries, you might be able to make an argument that it is. And I know that a lot of food production industry, food processing, some retail stores are using this for employees and have been for a while, the last couple of months at least. So, you look at the nature of the industry, people may be working closer together than you would like because of what they're doing, that they're an essential service, they don't want to get shut down. And think that there might be a proportionality argument to be made there for collecting employees' temperatures in those circumstances. But again, it's a contextual test. So if you want to start testing temperatures for all office workers, I think you're going to have a harder time meeting the balance of interest and showing that it's proportional in those kind of circumstances, particularly where you can limit the employees where they're working and if they can be far apart. If you're going to collect temperature, certainly you want to give notice. You want to make sure that the tests are done in accordance with an established protocol, least privacy intrusive as possible, and also combine it with notifying employees about the other symptoms and self-assessment tests. In some industries, the self-assessment tests, I think in silviculture, they're mandatory before you come to work. So have it as part of an overall protocol and not just use it on its own to decide whether employees can be at the workplace.
Yeah, and we're sort of working our way up in terms of some potentially more intrusive types of activities. So next on the list of potential questions that might be asked, can you require an employee to submit to antibody prick testing at this point in connection with return to work?
Yeah, and I know some employers are doing it, but I think there's real risks with that in terms of not being compliant with privacy legislation. It's obviously highly sensitive. It's medical information. The manner of collection, to try and do it in a way that's not privacy intrusive, as well as safe. So there's a lot of issues with that. I think the other issue is we still don't have a test that's been approved by the Canadian government. So we hear a lot about the reliability of the test being an issue, and I think that's also something that would be taken into account in a proportionality test as to whether it's appropriate or whether it's offside of PIPA. There's obviously other methods that employers can be using. All of the guidelines from WorkSafe BC for social distancing, for trying to keep people safe. And the other issue is, what does the test tell you? Even if it is a reliable test, it might tell you that the person did have exposure to COVID, but could they get it again? So there's just so much unknowns about it that I think that's a really hard one for an employer to implement without having some concerns, at least, about a privacy complaint. If you're going to do it, I would suggest you get some medical advice. We have a consultant, a physician, or other medical professional as to the efficacy and the safest way to conduct it. And I think that'll help you with your proportionality argument, but I still think it's quite risky. Mm-hmm.
Yeah. Lastly, just shifting a little bit away from the health-related employment privacy questions, onto the question that I know is starting to gain more steam and more interest and more media attention, is focused on whether and to what extent it's reasonable for employers to actively monitor their employees' productivity while they are working remotely using software or video cameras or other tools to stay on top of what employees are doing while they're working outside of the office. So if you maybe could address that for a minute.
Yeah, Alex and I were talking about this. There's a CBC article about some new technologies, or maybe they're existing technologies that employers are starting to use with a lot of employees working remotely, primarily to monitor productivity. And I do think there's concerns with that. There's a lot of orders in British Columbia that talk about continuous real-time tracking of employees' use of a computer is likely excessive and invasive. There's also the concerns about what you might be collecting, and I'm mindful of former Commissioner Denham's investigation report on the keystroke logging issues, that where you're collecting non-business information that goes maybe to the employee's biographical core, unrelated to work, that's definitely going to be an issue. But there are some orders that have allowed tracking, such as GPS, where there was a reasonable purpose for doing it. So the GPS cases, the employers made arguments about safety, being able to monitor for those purposes. I think if you're just monitoring for productivity, I'm not sure that's going to get you to the balancing test, but I think if you sort of carefully establish the rationale for why you need to do this, and think about how much information you're collecting as well. So maybe you can be collecting information about maybe the tickets that an employee is completing, and then only investigate if the employee is not meeting the sort of standard metrics that they're required to. So there's ways, I think, to do it, but I think you have to be careful. And also, if you're going to do it, you need to give notice, and you need to have a policy that takes into account how you're going to use this information, how you're going to store it, and what you're going to do with it.
Yeah, it seems inevitable that these will be questions that continue to be grappled with, as many organizations, of course, talk about, continuing to keep a workforce remotely and not going back into office spaces in some cases. So certainly a not completely novel set of issues, lots of ties back to previous decisions and analysis, but in some ways a lot of new as well. So
it will be interesting times to see where we end.
Yeah.
Yeah.
Excellent. Thank you.
Okay, welcome.
With that, I'll hand back to Antoine, who will moderate our next speaker.
Thank you, Alex. Just before we move a little bit east, I just want to say that we already received your questions. There are good questions. Continue feeding us with it. We will continue trying to answer them on the fly, or keep it for the end. So if Darren, you can join me. Darren Reed is a new addition to Fasken. He's out of our Calgary office, licensed both in Alberta and Saskatchewan. So far, I think he has spent more days in his own living room working for Fasken than at the office, which was not the plan at the outset. But Darren is a litigator. He's focusing, including on cybersecurity issues. He is described as a terrific litigator from Benchmark. So now you have to keep up to this for your presentation, Darren. Welcome with us.
Thanks.
So the first thing I want to cover out of Alberta, I want to see what updates there is in your province, and I think the first topic that comes to mind is what's going on around the Freedom of Information Protection of Privacy Act. So if you can cover the latest updates for us.
Certainly. Thanks, Antoine. And you're right, I have spent more time in this room than in my office. So looking forward to getting back. The amendments to the Freedom of Information and Protection of Privacy Act, the Floyd Act in Alberta, to some of the amendments that have taken place in British. In early April, through a ministerial order, the government lines for responses for requests for access to, and depending on they're generally doubled or tripled. So for example, under Section 11, the time limit for responding, where you make a request of a public body for your information, they had 30 days to respond before the amendment, and they now have 90 days. So that we're seeing a very similar trend, just to permit the public body's time, extra time to respond where there's access to information requests. And interestingly, this may tie into one of the other things I'll talk about, which is the Trace Together app that's been released by the Alberta government, for example, because if you are asking for your own information that's potentially collected by this app, the time limit to get a response is obviously extended.
Well, it's interesting because you see in Quebec, as for Freedom to Information Act, we didn't have any extension, but we had guidance from the regulators regarding the fact that let's try to open the dialogue regarding what's possible, what's not possible in these times. The Ministry of Justice has suspended all recourse, so you're delayed to take action before the Quebec to Access to Information Commission is suspended. So there's different approach than from one province to another, which is important to take into consideration. The Alberta tracing app is certainly something that is of interest and new to us. How does it function? How is it framed to work, the EAB Trace Together app?
So based upon a bunch of reading that I've done, both of materials issued by the government and third-party assessments of the app, in essence, it is pitched as a contact tracing app, and as I understand it, it is the first of its kind in Canada and possibly in the Western world to be released in response to the COVID-19 pandemic. And interestingly, and I'll speak a little bit more about this in a moment, it's not clear how much detail the Office of the Information and Privacy Commissioner in Alberta received before the app itself was launched. It's still under review, and I'll have a little bit to speak about that in a moment. So what the public are being told about this app is that the only personal data that is collected when you download it is your mobile number. And that's so that Alberta Health Services can contact the individual if they were in close proximity to someone with COVID-19 or otherwise. And with consent, what the app does is it exchanges Bluetooth information with other devices that the person who has the app comes in contact with. One assessment that I read related to this app suggests that it only logs those devices that you spend 15 minutes or more around. That's not something the government has said. It was a third-party assessment, which seems like a long period of time. I don't know whether I've read anything that suggests that you can, that 15 minutes is required to catch COVID-19. So the data that's being collected, clearly there are some parameters around it. And the data is stored only on the user's phone until such time as they may be contacted by the government, at which time they can consent and release the data from their phone. It'll be uploaded to the AHS and then utilized. And interestingly, they say that this app collects anonymized app utilization data to also improve the app across different phone models and provide a better experience. And I've read some information that also suggests that on Android-based devices, the app does not collect data currently, and I suspect they'll be changing this unless it's sort of open and running on the phone, as opposed to Apple devices where I think it can be set to run all the time. And the government, in issuing this app, which is completely voluntary, is relying upon certain sections of the Health Information Act and the Freedom of Information Protection and Privacy, the FOIP Act, which arguably permit the government, with the consent of the user, to collect the type of data that they say the app is collecting. Interestingly, there is quite a fulsome consent process that has to be gone through, and even when you are in the app, users can elect to trigger certain aspects of it, toggle them on and off. And you can revoke consent, but consent must be revoked by sending an email to a specific email address in the government. So, as you might suspect, general media sentiment in Alberta is a little bit suspicious of this type of app and what it's collecting, what it's actually collecting, whether it's vulnerable to access by unauthorized third parties, and whether or not the government is going to utilize it for the narrow purpose that it's actually stated it's going to use it for. And this comes to the next point I was going to make, that on May 1st, the Office of the Information and Privacy Commissioner released a statement indicating that they had received a privacy impact statement or assessment, sorry, on the app, and that they were going to undertake a review, and they had issued certain questions to the government about how the app operates, and that's sort of the last update we've had from the OIPC on it. So the app is still under review, as I understand it, from our privacy commissioner, and we'll see what they say about it.
Is it available live now?
It is. If you search or Google Trace Together app or Trace Together Alberta, you will get a government website that permits you to download the app.
Okay. Have you?
I have not, no.
So I understand there's nothing mandatory in the process.
That's correct. The government currently arguably cannot force the public to download this app and utilize it. It has to be fully consensual to comply with the statutory provisions that they're relying on to actually have the data collected and delivered to the government on request, with a view to obviously tracking clusters of coronavirus cases and trying to minimize impact to the public. So uptake is critical to its success, and I don't know, I haven't seen anything that suggests any sort of numbers or data about that.
Okay. Well, there's one topic I want you to cover in particular today, and it's related to cybersecurity and insurance trends. Speaking of the reopening of the business, I'd like to hear you about what has been going on in the latest week and what to expect and how to prepare for that.
Sure. Obviously, I think many of us are aware that with the sort of global spread of COVID-19 and some of the confusion and uncertainty in the markets and that sort of thing, we definitely have seen an upswing in cybercrime. Making inquiries in the industry and in other industries, it seems that we're seeing similar, and what I've seen in my practice is ransomware and social engineering fraud and sort of institutional type infiltrations, but with people separated from the offices, working remotely, and getting the channels of communication in place. Some fairly obvious incidents were frankly occurred, and there are weaknesses in the chains of how businesses operate and when they were trying to sort of unfold and learn how to operate remotely. So what I would say is that institutions need to remind everyone, if they have not already done so through their cybersecurity awareness programs, of all of the things they need to be vigilant for, and certainly emails that are out of place, switching of wire instructions last minute on transactions, and these kinds of very obvious things that, if we were all in an office environment, might not actually catch us off guard. The other thing that is becoming more obviously as we all sit in our respective places is the bring your own device aspect of things. And we now have a world where large corporations and down to the smallest of businesses, people are utilizing their own devices potentially in ways that they did not prior to the pandemic for business purposes. And that creates a whole new level of risk that ought to be managed, and that employees need to be trained for, because, as we all know, the biggest risk in any cybersecurity program are actually the individuals using the devices. So reaffirming and instituting programming for your employees that keeps that top of mind as they sit in their living rooms or dens or wherever they are is very useful. And on the insurance front, it's interesting, making some inquiries in the industry. The number of claims appears to have gone up, and anecdotally, I understand that premiums are obviously going to be affected by that. And the interesting piece about this is the take-up rate in Canada of cybersecurity insurance is still quite low comparatively to other parts of the Western world. And I think that we may see a change in the wind in that after this, depending on how industries are affected. one point of takeaway, circling back to the bring your own device piece, is that those with cyber risk policies should take a very close look at them to see whether the policies specifically address the types of devices that are covered, because many policies may not cover the bring your own device aspect of things. So institutions would be well advised to take a second look at the coverage they have in place.
Yeah, that's a good point. What I've seen is two things. First, there's more phishing COVID-19 related. So that's really something to be aware of, and the awareness and the training of the employees must continue more than ever to make sure that they are very cautious about it. The other thing I saw, speaking of bring your own device, is people that have difficulty to connect from home, so they might have a tendency to transfer the employer information on their own device or their own email address, a personal email address, which is outside of this, the security that you would typically apply within the enterprise. So I have breaches to deal with recently that are related to that. So sometimes it's just as you have a difficulty to plug your scanner to to your VPN, or so you would go through your own email address, you would scan a document and we'll send it to your business email address. But your personal email address is a free email address that's not protected. So that's the kind of thing that we've seen recently.
Right, and just to add to that, I mean, as soon as counterparties get used to people switching between email addresses and even phone numbers and that sort of thing, it creates opportunity for hackers.
For sure. Well, thanks for your thoughts, Darren. This is very interesting, and people keep coming with your questions. It's very interesting to see the topics that you want us to cover. Now we'll continue our march east. Alex, I'll let you introduce our next speaker.
Great. And there's Daniel. So Daniel Fabiano is a business law partner in our Toronto office in the privacy and cybersecurity practice. Daniel's practice focuses on the area of privacy and information protection, procurement and technology, as well as freedom of information matters and anti-spam. Daniel regularly assists clients with a full range of privacy compliance and related risk management matters. And I can say certainly has played a very leading role in some of the most innovative and significant data and privacy projects and transactions in Canada in recent years. So I'm really glad that you're able to join us today, Daniel. Thank you.
Happy to be here.
Terrific. So one of the questions that we wanted to touch on was a little bit in terms of some non-COVID privacy updates, because we have had actually some amendments and changes that had been in the works that aren't specifically COVID related, but that emerged during recent weeks. So we thought we don't want to overlook those. And if maybe you could touch on what we've seen on the health privacy side to kick us off.
Sure. Well, one of the big changes in Ontario was that our health privacy statute, which is the Personal Health Information Protection Act, it was amended at the end of March. And there was a number of amendments, but some of them are quite significant and quite notable. In particular, there is a new administrative penalty regime. So previously, the only financial penalties that could be meted out for breaching the health privacy law required some court proceedings. But now the Information and Privacy Commissioner of Ontario can mete out fines directly, whether against healthcare providers or their employees or their agents or their technology and service providers. All of them could be subject to new financial penalties. The purpose of the fines is, of course, to encourage compliance. But it's interesting that the statute also says that the purpose is to prevent a person from deriving economic benefit from breaching the law. So that's interesting. In terms of the amount, the commissioner will determine the amount, but future regulations will set out some parameters in terms of what the dollars might look like. It's also interesting to note that this is not an exclusive regime, that administrative penalties can be imposed alongside penalties under the offenses provision. So the health privacy law includes a provincial offenses section where if you are successfully prosecuted in provincial court, it can also lead to financial penalties. And what's interesting is that the amendments doubled those penalties. So in addition to being fined by the commissioner, individuals or organizations could face financial penalties. Now it's $200,000 for an individual, or $1 million if an organization is successfully is convicted under these offenses provisions. And by the way, for an individual, it could also be up to a year of imprisonment. These changes are also interesting because the health privacy law recognizes vicarious liability for officers, directors, agents, and others. So this is really a significant expansion of the commissioner's enforcement toolkit, but also, I suppose, the law in general. There were also some new technology requirements around new electronic audit log rules, and looking ahead, there will be future regulations that will set out new de-identification standards. So those will be very of much interest for companies that regularly deal in health-related data. But one thing that I'm really keen on seeing how evolves is a new regime. It's not yet enforced, but it's a new regime for entities that are known as, or the statute defines as, consumer electronic service providers. This is a provider of a service that allows individuals to manage their electronic personal health information, which could include sort of compiling it, modifying it, or sharing it with others. So those sorts of providers of portals or platforms or apps can, in many cases, not be covered by our health privacy law, because that law is very much focused on healthcare or healthcare providers. But these new rules around consumer-facing health technologies, could be quite significant. Now, at the moment, the amendments don't say a lot about what the rules are. They create a space for the rules to be set in regulations. But any company that offers consumer-facing apps or portals in the health space should certainly stay tuned for how this law will affect them.
Yeah, really quite significant changes, and with the offenses, the fines, the penalties, and the offenses. I mean, it's probably, at least in my experience, one of the most misunderstood things about Canadian privacy law, that there had been these mechanisms for fines, and everybody had overlooked the fact you had to be charged with an offense. So this is quite a groundbreaking move, and of course, perhaps a sign of what's to come under PIPEDA, under the federal law, with the commissioner getting powers like that to regulate the private sector more generally. So thank you for covering that. It's really quite important, quite significant. In terms of COVID-related developments, we could shift gears on that one just for a second. In terms of Ontario, have we seen guidance from the Ontario Privacy Commissioner similar to what Lorene mentioned in terms of the developments in BC?
The guidance in Ontario has been quite brief. It is, of course, focused on public and healthcare entities, because Ontario doesn't have a general privacy statute. So the jurisdiction of our commissioner is limited to the public sector and to healthcare entities that are governed by the health privacy law. Again, brief guidance, very pragmatic in terms of recognizing that we're in exceptional circumstances, and that government and healthcare entity employees may need to be working from home, and that that may involve sort of security measures that in normal times may not pass muster, but that an assessment of the rigor of those measures would be made in the context that we live in. So it was a very pragmatic statement from the provincial commissioner.
Terrific. And switching gears to the federal side, developments from the federal privacy commissioner.
Sure. There was, I think, 3 guidance documents issued. One was largely a consolidation of existing statutory provisions, almost like a thumbnail sketch of how an organization might work their way through, say, a disclosure of personal information based on an exception to consent and so forth. So, I don't know that there was much new there, but it was a useful resource for organizations. Another piece that I think, and I'll talk about in a moment, was some guidance around contact tracing apps. But one piece that is worth mentioning is mainly targeted to the federal government, and it's a framework document for the government of Canada, for federal institutions to assess initiatives for privacy, basically COVID-19 responses in light of privacy. And that was issued in April.
Yeah, very important, and could provide some models for private sector, even presumably in terms of some of the guidance there. So you mentioned contact tracing, and we've heard a little bit about that from what's happening in Alberta and across Canada, and of course can impact us all as individuals, as well as have other implications. Maybe for those who may not be following that closely, what is contact tracing? Why is it useful? Maybe a little introduction on that, if you could.
Sure. Well, it's not new, first of all. It's actually quite a common epidemic control measure. It's been used for all sorts of illnesses throughout history, more recently SARS, measles, and so forth. It's basically detective work where tracers attempt to understand who an infected person was in contact with during the time when he or she was contagious, so that those individuals can then be alerted and given specific information about the kinds of precautions they should take. So largely self-isolation for a couple of weeks and so forth.
Mm-hmm. Okay. And in terms of the models for how that might work, presumably that may involve some different methods for contact tracing. Can you maybe touch on that?
Sure. Well, there's a lot of discussion around technology, leveraging technological solutions, which makes a lot of sense, because if you think about it, 50 years ago or whatever, at its most basic level, right, tracers just have to work with the infected person, right, helping them to remember where they'd been and who they had contact with while they were contagious. And so if you sort of move that into a technological model where you're using technology to help, you can really address some of the obvious deficiencies or problems with trying to deal with an in-person kind of interview and helping someone piece together their life, right? Because doing that is slow, and any delay means further spread because people that don't realize they may be infected are off infecting others. It's also likely incomplete because we have flawed memories and we don't remember where we were at every moment. And maybe most significant, it's difficult to actually tell people. So even if you figure out who it is that the individual might have been in contact with, how do you then let those people know, particularly if they may be strangers and the individual may have no idea how to get in touch with them? So technology can significantly address all of those issues, and it's widely recognized that technology, that digital contact tracing will be a critical tool in helping us contain and manage this virus going forward. I think that's sort of an unquestionable piece or a fact that has been, or opinion that has been espoused by most commentators. How you do digital contact tracing can fall on a whole spectrum of approaches. So at one end, you could have a highly centralized model where basically it's mandatory and everyone's data is being collected and gathered in a central repository. And it works sort of in that vein. That's clearly not a model that I think would work here in Canada. But at the other end is a decentralized model. So a voluntary system where most of the data is stored on the user's phone. And if the user is diagnosed with COVID-19, then the user, similar to the Alberta scenario, I suppose, can tell the app, which then alerts other app users. I suppose, unlike the Alberta scenario, a truly decentralized model would not involve a disclosure of information to a public health authority. The app would mediate the information transfers. There would be no need for anyone to pry into or look at a data repository. And you could use Bluetooth technology and so forth, similar to what Google and Apple have put forward. There is a middle ground. I think Alberta is trying to straddle that middle ground, which is to use a decentralized model, but to have a public health authority available to then receive the data and then act on it. Right.
So, I mean, without question, there are privacy issues embedded in there. Could you maybe give us some highlights in terms of where some of the privacy issues are being bumped into?
Sure. I think the threshold issue is who controls the data. Is this a private sector entity? Is this a public sector entity? Even if it is a public sector entity, how does the app or the technology get developed? Presumably there is a private sector service provider somewhere in the mix. So who's in control will determine which privacy laws apply. Are we going down a public sector route or a private sector route? It's also, I suppose, possible that our health privacy laws provincially might apply. Another, and probably the more pressing concern, regardless of who runs the thing, is how do you limit the collection of personal information and how do you protect the anonymity of individuals. Really, how do you avoid this from becoming a mass surveillance tool or a tool to affect discrimination, right? Digital contact tracing should warn people that they're at risk, but without revealing who might have infected them. So it's, the question is really, how easy is it for the app administrators or the government to be able to identify individuals inappropriately or inappropriately re-identify individuals based on location data, timestamps, and so forth. And simple assurances that, oh, well, the names and telephone numbers are masked, so the repository doesn't know that information. That's not necessarily a complete solution. And there is research, I know there's an interesting article in the Nature publication citing some research that basically says, look, if you have a database, a mobile phone database of 1.5 million people, if you can gather 4 time-place data points, just 4, where you were at a given time, that can be enough to identify 95% of the individuals in that database. So there is a real concern with the amassing in a central repository of all of this data and how that might be used. Obviously, there's concerns about security of that repository as well, plus security on the individual apps that are running around, and whether bad actors, villains, and so forth could leverage that and make mischief or cause harm. Another interesting point is, how do the provincial solutions work together? So different provinces, are looking at different technologies. And there's a clear concern that this may result in different privacy standards across provinces as each uses a different approach. But another concern, and this goes back to some comments I know Lorene mentioned about proportionality and effectiveness, and I know that's featured in some of the federal commissioner's guidance, right? That the measures you deploy need to be science-based and so forth. Well, how do you deal with effectiveness when one province's contracting tracing scheme doesn't really interface or work with another? So where individuals are crossing borders, never mind long distance travel, but at the borders. So if you're in Sackville, New Brunswick, or Lloydminster, Alberta, or Ottawa, or Gatineau, how do you deal with the fact that on a daily basis, individuals are crossing a provincial border to work or live on the other side? And so how do municipalities then manage that? I mean, does it mean that residents of Quebec need to defensively register for the Ontario app because a bunch of Ontarians are coming across the border to work in Gatineau? There's sort of interesting implications for how this works when we look at look at the provincial borders.
Yeah. And briefly, in just a minute, privacy commissioners presumably are weighing in on this. We heard a little bit about Alberta. Just a quick remark on that.
Yeah. So very briefly, earlier this month, all the privacy commissioners, federal, territorial, provincial, issued a joint statement. They highlighted privacy principles for contact tracing apps. And maybe just to highlight 2 of the principles. One is consent. As far as the commissioners are concerned, this has to be a voluntary program, and it has to engender trust. And in order to do that, there needs to be privacy impact assessments, independent oversight, and monitoring. That this really needs to be something that governments don't go off and hire a private sector company to help them with. That it really is subject to a lot of transparency and a lot of rigor. And that's really meant to address the fact that if different provinces go in different directions, the public sector privacy laws across Canada are not well equipped to work in a digital environment, and so they really could let individuals across the country down.
Yeah. Thank you so much. Fantastic coverage of some really key issues. With that, I'll turn it back to you, Antoine, to move further east with our next speaker.
Thank you, Alex. We're now moving to Quebec City with Kateri-Anne Grenier. Kateri-Anne is a litigator who has in-depth knowledge of issues regarding personal information at the federal and provincial level. She's really involved, as I am, on breaches, multi-jurisdictional breach, litigation arising of that, how to mitigate risk of prosecution resulting of breach. She co-authored a book on the application of the privacy legislation in Quebec. So let's kick off this discussion, Kateri-Anne, with what's going on in Quebec. I've alluded, and Daniel also, to some of aspects of what has been going on in Quebec recently. Can you expand on it?
Yeah, of course. Hello, everyone. Good afternoon. So Danielle finished his presentation by mentioning the joint statement, privacy principles for contact tracing and similar apps. So as a first item of my presentation about what's new, I should point out that the Quebec Privacy Commissioner also did sign this joint statement. And in addition to the joint statement, if you're interested in contact tracing and technology related to the privacy, then you may go and see the Access to Information Commission website. They have a dedicated COVID-19 section, and you can also see the guidance tool that the Commission published respecting privacy issues and technology. So that's a first item of what's new. A second item is that unfortunately, COVID-19 has temporarily stopped the ongoing efforts to modernize Quebec's private sector privacy legislation. So it is to be expected, unfortunately, that the filing of a new bill will be delayed. However, we can say that COVID-19 definitely demonstrates once again that the modernization of Quebec's privacy legislation should really be a priority, especially on issues such as electronic data, consent, and collection of personal information in a health crisis like the one we're living right now.
Well, in fact, speaking of privacy legislation, what we see right now is one of the main challenges throughout the world is research. And can you tell us a bit about the hurdles we have regarding research in Quebec with the privacy legislation?
Yeah, well, I'm not an expert on the provisions of Access to Information Act regarding research, but I can say that it's a pretty lengthy and sometimes burdensome process, because we often have to seek authorizations from the Commission d'accès à l'information for specific projects research, and the process is not viewed as ideal. It is viewed as lengthy and really needs to be modernized. So I think that's also an aspect that should be made better in a future legislation for Quebec. That's for sure.
And can you tell us if the Access to Information Commission in Quebec still works during the crisis?
Well, not much. Like many other courts, the Commission d'accès has suspended or reduced its services to the population. So that includes hearings. I think that the Commission might be able to deal with urgent complaints from citizens regarding urgent situation, but as we all are, they are dealing with more limited resources on the ground. So regarding the hearings, we know that all hearings for March and April were canceled. They will be rescheduled at a later date. May hearings have been either postponed or have proceeded by telephone or in writing. And as for future hearings from June to September to come, the Commission has announced that it will hold hearings by telephone. And depending how the situation evolves, video conferencing may be introduced later in the fall by the Commission d'accès, as is done presently with many courts here in Quebec.
The overall topic today was the reopening of the business, and one of the challenges that we could foresee is all the B2C business. How can we interact with customer when we're afraid that they are carrying the virus, but we still want to do business and we want to protect the employees? And so I'd like to hear you about your views on how we see the reopening in that context, where we're opening the stores, and especially in the retail business, we'll have people coming in our stores to shop for many things that they haven't been doing for the last 2 months.
Absolutely. And we all know that in the province of Quebec, as the case is in other provinces, there is a progressive reopening of the economy, and in many regions, in many areas, stores have started to reopen, as well as workplaces. As was mentioned by Lorene a bit earlier, Quebec is also a province that has adopted guidelines and rules regarding health and safety. So I think a standard for most stores would be to comply with the measures that are taken by public authority, that's for granted. However, as you mentioned, the suspension of the economic activity in the last weeks really impacted B2C oriented businesses. And, some businesses were forced to close down. Some will be slowly reopening. Some were authorized to stay open, but, they made a lot less money because they could have a lot less consumers on the ground to shop. So a lot of B2C oriented businesses right now, I think they want to make up for the time that they lost. They're asking themselves how science and technology may help them attract consumers and also keep the public safe. And when we read the news, a lot of the strategies contemplated by merchants, on top of what's already being said by the public authorities, may include asking health questions to inquire about, for instance, symptoms. Are you coughing? Are you sneezing? Do you have temperature? Or about a person's recent whereabouts. Have you traveled? Anybody in your family sick? Have you been out of the province? Have you, etc. Other methods that we see that are maybe steering a bit more controversy is taking body temperature. We've talked about it earlier in the workplace, but we have seen retail stores. We know that airlines have indicated that it will be a measure that they wanted to implement. So taking body temperature either on a one-on-one basis or using a technology, infrared technology, for instance, that screens a group of customers entering the premises and indicating body temperature for each. And then obviously, if the body temperature exceeds a certain degree, then an action is taken by the merchant vis-a-vis the consumer to say, well, you may not be able to shop here, or we may recommend that you order online, or you will not be able to board that plane.
So in other words, they would tell the customer, you're too hot for that place.
Too hot, exactly. Too hot to handle, right? So, and I know that the risk here, I believe, is that since we've been in our houses and, confined to our houses and unable to travel and unable to go to the store, I think people will be willing to accept a lot more than they would be without minimizing the health crisis. But I think people will be really open to sort of do anything or answer any question that's requested just to be able to enjoy their freedom. But at the same time, it does raise important questions about privacy issues, especially, I believe, asking health questions and taking temperature. So, of course, each case is unique. So, like the comments I make, they're really intended to help businesses to have an understanding of what they can or cannot do with the legal framework, and also what assessment you should perform before you even consider using these measures.
Speaking of privacy, I hope your son knows that we're seeing him while he's on the bike.
I have I have no control, it seems, over him.
Speaking of body temperature, I have a question for you. We've been reading on, scientifically papers on how relevant is the body temperature in the COVID-19 crisis, where we learn as we go. So can you say a few words about what are the takeaways regarding what we read on how efficient or how relevant is body temperature for access to store, for example?
Yeah, you're right, Antoine, because the more we read and the more we listen to health officials, the less relevant body temperature becomes in assessing whether a person may be carrying or not COVID-19. So what we need to remember is that even during the pandemic, privacy laws, individual rights continue to apply in the province of Quebec. So this means that, a person still has the right to dignity, privacy, inviolability, safeguard to your reputation, right to your private life. So the test to pass normally when you want to justify publicly that you will restrict or infringe a right recognized by the Charter or the Privacy Act is that you need to have, first of all, a legitimate goal. And the goal, in my view, has to be a little more precise than just, preventing COVID-19 to spread around the world. The goal really has to be able to clearly give a benefit to the public because of the measure you're implementing. And the second criteria, on top of having a legitimate goal, is the method that you're going to be using, does that have a direct impact on how you will reach your goal? And is the method in a way necessary to achieve the goal? And in a way, have you also are you using the less invasive method that's available to reach the goal? And this is where your question really is relevant, because even if you have a reasonable purpose, if taking body temperature is not a efficient, scientifically recognized way to detect COVID-19, then the prejudice or the discrimination becomes greater than the protection that you will give to the public, and that's, I think, a problem. I read a few articles and was also thinking about this issue. We know that Dr. Tam issued a few statements saying, body temperature, as far as COVID-19 is concerned, not a great factor, because we know that a lot of people may be asymptomatic. We know that people who have fever can take pain medication or medication to make the symptoms disappear. So what does that really tell us? We also know that a person's temperature may be higher than normal because this person maybe has exercised before she entered the store. Maybe this person has another health condition that's unrelated to COVID-19, but that can give symptoms. So you're really using a method that raises a lot of question, I believe, as to, is this really a recognized scientific tool to prevent COVID-19?
And the thermal scanner may not be as reliable as we would want. So maybe the reading will be off as well. Last question for you. We had the discussion in Quebec regarding the wearing of a mask and the issue of individuals' rights and freedom. And some of our clients in the retail business could see the wearing of the mask as a potential way to reopen their businesses and to impose on their clients to wear the mask. Do you have or gloves or any kind of gear to try to limit the exposure of the virus? Mm-hmm. Do you have a few thoughts on this possibility?
Exactly. Well, on this aspect, I think, first of all, my thought is that wearing a mask or wearing gloves could be seen maybe as less invasive than temperature taking, because first of all, you're not asking for any personal information, right? Taking temperature or asking specific health questions does require for an individual to provide personal sensitive information. So wearing glove, wearing mask, first of all, you don't collect PI. Second of all, I think that generally speaking, in the last news updates that we've seen from the authorities, this is considered more and more as an efficient way, not the only way, but as an efficient way to protect yourself against COVID-19. So I think it would have more credibility, I believe, as a measure. I think that for a retailer, for instance, the best way to do it would be to have some gloves or masks, if possible, to give out to consumers. That way, you're sort of keeping everybody happy. You are not asking people to turn around, or you're not asking people not to board the plane, but you're giving them the tool, and you're also giving them a place to dispose of the gloves and the masks once they're done with the shopping. So I would see that this measure would have, of course, less of an impact on privacy and personal information, and does seem at a first glance as a more effective measure, at least more recognized by the authority than taking temperature.
Thanks a lot, Kateri-Anne, for your input. We'll see you around in the Q&A session as well. I'll be moving now to Jennifer Stoddart, which you all know. as the former Privacy Commissioner of Canada from 2003 to 2013. She chaired the Access to Information Commission before that and was part of the Human Rights Commission of Canada in Quebec. So she knows it all, and she certainly have a few words, a few takeaways of the current situation in the privacy field that she could fill us with. And after that, we'll move to the Q&A session. So feel free to continue sending your questions to us so that we can deal with it. Hi, Jennifer. Thanks for being there.
Hi, Antoine. Thanks for making me part of this really interesting and relevant, up-to-date discussion. It's been really thoughtful to hear all the colleagues from across Canada, very useful. And just briefly, because I know there's a lot of questions, I'm impressed about how the situation is so fluid. A lot of the remarks that people made, whether it's about apps, the latest information on temperature taking, on back to work procedures, on health legislation that's changing, tells us just how intense this experience is, and therefore how we all have to really watch what's coming up and learn how the principles are changing so that we can better comply with them, whatever our situation is, whether we're managing employees at home, or other situations that have been invoked. In this very fluid, difficult situation, I'm encouraged as a former commissioner to see how often privacy principles are invoked and how careful we are about trying to respect them within provinces, within Canada. And of course, Canada is linked in internationally with its partners and allies, and how we are trying to share information and make sure that globally we advance towards an appropriate solution, health-wise and society-wise. And finally, I guess this is me as a former bureaucrat saying, I think in Canada we've shown a response that is reasonable and moderate, and I think that's a great kind of attitude to have going forward in very provocative, stressing situations. We have reasonable and up to now moderate responses from all our levels of authority. We have a population that voluntarily goes along with information, with guidance and so on. I've only noticed myself one kind of penalty, and that was for somebody under the Quarantine Act who I guess wouldn't stay at home. I hear in labor law circles that sometimes an employee comes back who shouldn't have, but the most the employee gets is a day of salary that's docked. That's no huge penalty. So I think we can be confident that we'll get out of this. We have a society that's based on the rule of law, and Canadians are confident in the existence and the enforcement of their privacy rights, as all the speakers have said.
You were, I think, at the end of your term when the SARS crisis hit Canada at the time. How different you would see on the privacy standpoint is the reaction and how we deal with the current virus, which is certainly bigger in its impact. But do you see that there are some takeaways from the 2013 crisis that we use or we could use now?
Yeah, not so much, I think, in terms of privacy. I think I'll take that back. There were privacy problems at the time, but remember, SARS was mainly confined to the Toronto area.
Yeah.
And so maybe some members here who worked through that in the Toronto area would have a more vivid memory of the problems in the Toronto hospitals. As you say, this is now nationwide, although I'm sitting in what's supposed to be one of the hot centers of Canada in Montreal. We're certainly reacting more quickly. There's more guidance put out. I think guidance was very slow to be put out. It's like people didn't believe that this kind of thing could happen. Now we do, and we know that there may be a second wave coming, so we become more nimble. And I think, as I say, the population understands better what is happening. I think has more confidence in the authorities that they too have learned from the SARS crisis. Perhaps where we have still more to learn is the protection, how to protect employees more quickly. A lot of employees have been very badly hit in particular industries, in particular settings across Canada. That was very bad in SARS. I don't think it's improved now. We have to find a long-term solution to having so much of our workforce so exposed.
Well, you see, I was in Toronto at the time, and you know, there were people wearing masks in the street, and I felt it was weird. And we were not used to that. It's probably a cultural thing. But I think now with the current situation, we'll see more and more people adapting, wearing masks and adapting their social interaction more than what we have seen in Toronto in 2013. Well, thanks a lot, Jennifer, for your thoughts.
Thank you, Antoine.
Stay around for the Q&A sessions. Alex, you could get back with me, and I might kick off the Q&A session with the one question we received from Caitlin an hour ago. Caitlin was asking if it was better to have a standalone COVID policy or amend existing policy given how long this may last. This is a very good question because it depends what you're doing differently during the COVID situation, because there are some policy that already provides for some testing in the workplace when there are some sufficient doubts that an individual would have a virus or disease that would not permit to work or be in the workplace. But to the extent that working from home is only very temporary, that you would want to implement some testing that would be of limited time because of the current situation, you may want to prefer to have a standalone COVID policy. And we have done some recently. But at the same time, it could be the right opportunity to review your own privacy policy and see how do you want to deal with this, and how do you want to amend your practice on a more permanent note. I don't know if you have anything to add on that note, Alex.
No, I think it's a good question, and certainly one that is going to be context specific in terms of what types of policies already exist. To the extent that you have work from home type policies already. In that context, you may say, well, there are just a few tweaks that we're going to have to make to that one. We don't need a COVID specific solution, especially if a lot of these new ways of working are likely to continue to exist post-COVID anyway. So, certainly for some, I can see, the way that it's unfolding is tweaking some existing policies where appropriate, and in some cases developing practices and policies that are definitely specific to COVID, because there are some unique considerations around that, and ones where it seems appropriate to build a special set of policies there. Yeah.
So do you want to take the next one?
Yeah, so I had one that I think might be a good question for Lorene. And this was back to some of the discussion around employees. And the question was, can you ask employees to submit their self-assessment to their HR or managers daily or weekly? And can or should the employer be keeping those self-assessments as records for some period of time? So, Lorene, if you're able to come back on, if you're able to address that one.
Yeah, it is a good question. So, essentially you're collecting personal information and you have to think about the purpose for why you're doing it. If you've notified employees, you can't come in if you have symptoms. You've got the proper signage up you're required to in BC. You have policies and training about all of that. Then what is the purpose of collecting the information? And I think the way I would analyze it is maybe you're balancing the risk between protecting yourself from a future possible negligence claim and potentially being overly privacy intrusive. In British Columbia, essential services have protection from liability in the legislation, but I think we're quite unique in that in BC. Non-essential services don't have that same protection. So if you're thinking about how do we meet our duty of care, we follow all of the OSH guidelines, we follow what the public health is telling us to do. But if we got a claim and we had some evidence about the fact that we knew what the status of our employees' health was at the material time, would that be of help to us? So if you analyze it that way, if you're concerned about the liability risks, if that's a reasonable purpose for collecting that kind of information, you might be able to make a rationale for it. But again, if you're going to collect it, make sure you protect it, secure it, only use it for the purposes, and think about really how long do you need to keep it. I think it should be a short retention schedule.
Yeah.
Thank
Thank
you,
you.
Lorene.
Antoine, do you want to take
Yeah,
another
I'll
question?
take the next one, and I'll ask Jennifer to come back. I think it's an interesting question, and maybe relates to what we've seen in other regulatory sector. The question is, can we expect Canadian privacy regulators to put on hold or to soften data protection enforcement during this pandemic, similarly to the ICO approach? It's interesting because we have seen some example like the Competition Bureau as taking a different approach during the pandemic, because competitors now have to work together in order to assure a chain of supply, especially in the food processing industry. But I don't know if Jennifer is still around, but my take on this is that we're not having a trend to have privacy regulators to be more lax regarding privacy before COVID. So I think it would be a wrong message to send to change this point of view. With the GDPR, with the California amendments, we're moving towards legislation that will be amended to be more stringent. So I think this is the trend. But Jennifer, can you tell us what you think about that?
Okay, sorry, my system was a little off there. I think that regulatory authorities will be concentrating on the fallout, if any, from the COVID events. If you're an access to information commissioner, there's the extended delays. How long will that last? Will that be an excuse for government, for example, simply to give information even slower than historically it has? Mm-hmm. If there are any kind of test cases that regulatory authorities would like to investigate or opine on to give guidance to the public, to business and so on. But I think many of them are concentrating either on upcoming change legislation, a change of guard, for example, a new commissioner in Ontario, which is a huge and very important province in this. I understand that Innovation Canada is going ahead with the changes to PIPEDA, but when that gets on the order paper of the virtual House of Commons is another question.
Thank you, Jennifer.
Maybe I'll just add a comment on that, just because I've seen a little experience in terms of actual things that are under investigation and dealings with the regulator. And yes, while it's true there was a quiet period as everybody adapted, in March, I would say the experience that we've seen with a lot of clients is that the commissioners are tolerant of a little bit of delay in understanding that there may be a little extra time to respond to things, but they're still doing their job in terms of conducting investigations, enforcement, and that there's no reprieve. It's just a question, a little bit of maybe a little bit slower than usual, but by and large, all the rules continue to apply, and the experience continues to be pretty similar to what it's been historically.
Yeah, I agree with you. I have seen investigators giving pretty tight deadlines in the latest weeks in order to provide response. No different than the usual deadlines that we would get. So So I don't, it's not the time to be more lax about privacy because we think the regulators won't bother. That's, I think, the message we want to convey.
Yeah. Maybe we have a few minutes left, and we have tried to address during the course of the presentations the vast majority of the questions that came in before the session, and to some extent the questions that have come in live during the session. So we hope we've covered most of the bases in terms of the questions that were on people's mind. We may have an additional opportunity to provide some additional responses directly by email if any folks want to reach out, or through our Twitter Q&A session that will follow this session. So don't worry, you may get an answer if you haven't heard it. But I just wanted to circle back on one question for Daniel, because I think this is one that's come up and is one that may increasingly get some profile on the horizon, which sort of deals with the interface between the sort of individual participation in contact tracing, and where that may come to raise questions for businesses in private sector for information sharing and information about customers or employees, and those types of concerns that may continue to be on the radar. And could you comment on that, Daniel?
Sure. Well, short of some sort of statute being enacted that compels organizations to hand over information about the whereabouts of their own employees, or what customers have come in and perhaps purchased things, if it's, say, a retail store. I mean, short of legislation being enacted, you see this as really a set of voluntary arrangements where organizations are choosing to respond to external requests for information, or choosing to collaborate with other entities and to share information to help contain the spread of COVID-19. The moment you're in the voluntary zone, you need to take a very close look at what exemptions are available under the privacy law that applies to your organization. So if you're a private sector organization, under one of the PIPAs or PIPEDA or the Quebec Act, can you fit within one of the exemptions? So mainly, the exemptions that speak to emergencies and public health and safety situations. When you're in a voluntary disclosure zone, in that sense, you really do need to be comfortable with the rationale for why you're engaged in what you're engaged in. And I think looking to the joint statement, the guidance around COVID apps, admittedly, they're about apps, not about sort of non-app programs or initiatives, but looking to that guidance and working your way through it to make sure that you're comfortable before proceeding with how your contact tracing program or what sort of disclosure or information you're sharing. I think that's a really important step. Right now, I don't know that there really is much in the way of guidance for the private sector on how to deal with the specific topic of contact tracing. It's targeted at the public sector because that's the sector that's going to be, doing sort of province-wide apps. But I think there's no harm in looking to that guidance and analogizing accordingly.
Yeah. Thank you. Yeah. Back to you,
Thank
Antoine.
Maybe just before we conclude, Alex, there's one thing that we've been alluded to, especially by Kateri-Anne, regarding the privacy assessment. When we talk about making a privacy assessment, it seems a very complicated thing. Clients are often afraid that it will be very long, complicated. And do you want to touch a few words, Alex, on, in fact, how does it work, and how does it proceed in reality when we have to do a privacy impact assessment?
Well, honestly, I defer over to Kateri-Anne or anybody else who wants to talk as moderator. I don't want to hog the mic. Kateri, I don't know if you want to speak to that.
Kateri, do you want to say a few words?
Yeah, sure. Yeah, as you say, Antoine, it doesn't need to be complicated. It's an exercise that can be done in-house with the help of legal counsel whenever that's appropriate. But it can be done by, first of all, defining the project, like working with people in the company that will implement the measure, and having a group discussion and assessing a few questions, important questions, key questions, such as what exactly do we want to do? Why do we want to do it? How is what we want to do connected with, you know, the legitimate purpose? Very important to define, are we going to be collecting personal information at all while we do this project? If we are going to collect personal information, are we sure that, first of all, we connect only what's necessary and that we minimize to the maximum the amount of data that we are collecting? Once we define that, also something to make sure is that you clearly define what's primary and secondary purpose, because sometimes, and in most cases, it's perfectly legitimate. In some instances, the company will have the project to collect personal information for primary purposes, but then being able to reuse this information for secondary purposes, or a portion of the information for publicity, for marketing, for having a better understanding of their customers. And if so, then it's important to define the purposes and to also think about how you're going to inform the people of these uses. Also, and I believe all speakers have spoken about it today, one of the key aspects to the assessment is where will the information be kept? What are the security measures that we're going to be implementing to safely store any personal information that we are collecting? Are we going to be transferring this information at some point? Are we going to want to send it outside of the province, outside of Canada? So that's a few examples. How the information will be retained, and is this the kind of project where we should be considering, for instance, updating our privacy policy? Should we be thinking about building consents, etc.? And also, at the end, is personal information going to be disclosed once we've collected it? So basically, it's sort of answering the 5 W's of what, where, and etc. And the basics of what cycle also the personal information is going to be getting through. So as I said, this can be done internally, but we strongly recommend that for certain projects that trigger some privacy issues, you be accompanied by counsel to complete the assessment.
Thank you, Kateri-Anne.
Thanks. Okay.
So I think we're up to the end of our session. Do you want to say the last word, Alex? I'll save it for you.
No, thank you all to our speakers, of course, for joining. If everybody wants to come back on the screen, we'd love to see your smiling faces, of course. And of course, thank you to our incredible audience. Really amazing turnout today, and a testament to the importance of these issues and ones that we're all grappling with and will continue to grapple with. And so, again, if you have any additional questions, please don't hesitate to contact any of our speakers directly anytime. And as well, we will have the Twitter Q&A to follow this webinar session, so please look out for that as well. And so that's it for me. I don't know if we had any other final wrap-up remarks, or are we complete?
Thank you, Alex. Thank you, everybody.